Latest visa extensions and variations of the United Kingdom immigration. In today's video, we'll be looking at the latest updates on visa extensions and variations in the UK. Short-term to long-term status. Can a short-term visa be converted into a longer-term authorization within the country? If so, what is the process? A person on a UK short-term immigration route, such as a visitor, is not permitted to apply from within the country, known as switching to a long-term immigration category. Long-term extension. Is it possible to extend the long-term immigration permission? An applicant can extend the long-term immigration permission depending on their immigration category. However, there are limits to the number of times an individual can extend their visa and the duration they can hold the long-term immigration permission. For instance, the maximum period an individual can possess a Tier 2 general immigration permission is 6 years. Workers in the United Kingdom under Tier 2 Intra-company Transfer can only stay in the UK for up to 5 years, unless they earn a gross annual salary of £120,000 or more, then the maximum time limit becomes 9 years. Exit and re-entry. What are exit and re-entry rules and implications apply to work permits? There are no limits to the number of times individuals possessing immigration permission may exit and re-enter the United Kingdom. Permanent residency and citizenship. How can immigrants qualify for permanent residency or citizenship? Some immigration categories permit migrants to gain indefinite leave to remain ILR, usually after holding 5 years of immigration permission under the same category. An individual is typically required to hold an ILR for at least 12 months to gain British citizenship. The applicant must meet certain residence requirements to gain permanent residency or citizenship. Requirements for residence are stricter for citizenship than for ILR. End of employment. Must immigration permission be cancelled at the end of employment in your jurisdiction? At the end of a sponsorship for a Tier 2 migrant, for example, because the employee leaves the company or obtains ILR, the employer must inform the Home Office. Suppose the migrant still holds Tier 2 immigration permission. In that case, the Home Office will normally give the individual 60 days either to leave the UK or to apply to remain in the United Kingdom with new immigration permission. Restrictions for employees. For a holder of employment permission, are there any specific restrictions? Under Tier 2, the individual is restricted from working for the employer sponsoring them in the role specified on the certificate of sponsorship. They are permitted to undertake supplementary employment, granted it does not conflict with the job they have been sponsored to do. So, what falls under supplementary employment? It must be a job equivalent to the profession and at the same professional level as the job they are sponsored to do. Weekly working hours must be 20 hours or less. Must be outside the normal working hours of their sponsored job. The individual must not engage in self-employment, and they might be allowed to study, granted it does not interfere with the sponsored job. The individual can be promoted from their current position with a change to their salary, provided the job role remains within the same standard occupation classification as stated on the COS, and the salary is above the minimum salary requirements for the SOC and Tier 2 category. This is the end of today's video update. Make sure to like and subscribe to our channel to keep following the latest immigration updates. Thanks for watching.